To this now, in a unanimous ruling, the Constitutional Court has declared sections of the Refugees Act unconstitutional. Now, the case was brought by the Scalabrini Centre of Cape Town. The centre took issue with some sections of the Act which provided that an asylum seeker was presumed to have abandoned their asylum application if they did not renew the visa within 1 month of its expiry. Now, let's speak to Canny Maphanga, who is SABC News legal reporter, just to get a sense of the significance of this judgment and for her to take us back to how we got to this point. Canny, thank you so much for your time. Let's help our viewers understand. Let's take a step back, talk about where this matter comes from and how significant it is.
Well, indeed, Bongiwe, the significance here is that we are dealing with refugees that are dealing with a specific circumstance when they do come to South Africa to seek that refuge. I mean, you're talking about persons that have been displaced, persons that are constantly living in flight because they may be running away from persecution, harm, or any of those other reasons that require one to apply for asylum. So, of course, when you apply for asylum, that application can take some time. For some, it can take a number of years for that final determination to be made. So in the interim, asylum seekers are issued with permits. However, they are dealt with in terms of the Refugees Act. However, the impugned legislation that the Court unanimously confirmed was invalid, constitutionally invalid. However, leaves that part to state that if, for example, you go and get your visa, your asylum visa, and it expires in 3 months, and you experience some hurdles for 4 weeks and you're unable to renew that visa, mind you, there are a number of hurdles why that does happen for asylum seekers, then you are deemed to have abandoned your application, which then leaves you out of status. Then you're dealt with in terms of the Immigration Act. Now, we all know the risks that are involved when you are now dealt with the Immigration Act and you're now undocumented. So it leaves you with a number of risks, and this is why this judgment is extremely important today.
And let's talk about then, what does it do then for those particular concerns that they would that they would have? Because if, for example, you think about the fact that when they go to the office, there's long queues, they sometimes don't even get inside the office to be able to renew, and it could even be like a process that takes a while, as you say.
Yes.
How then do they move at a practical level now, post this judgment?
Well, it gives asylum seekers, specifically children that are involved in these applications, protections. So it means that just because you have not gone through the hurdle of the renewal of a visa in time, it doesn't mean that now you are not afforded the protection of being able to live, work, study, etc., have bank accounts, have a place to stay, or any of those protections that are afforded to people who have status in the country. And you're not at risk of an arrest or being detained for deportation and being sent back to a country that you fled for various reasons. So the Court has unanimously correctly decided that that impugned legislation is in direct contrast with non-refoulement. That's a legal principle under international law, that you can't send persons back to a country that they fled for various different reasons, such as harm, persecution, etc., etc. So the Court has decided that that impugned legislation is unconstitutional, and Home Affairs, once they got to the Concord application, agreed that that legislation should be done away with anyway. So that should be the end of the issue, and refugees still have that protection that if they haven't gone through that hurdle of ensuring that that visa is done on time, they are still afforded protection and seen as refugees until that final determination is made by Home Affairs. So because Home Affairs has conceded, as you say, and their attitude now going towards the Court, does it mean then that these sections are done away with as a matter of now immediacy, or are we still going to be seeing time when it comes to some of these changes kicking in, or do they kick in immediately? They kick in immediately. The Court has clearly stated that the impugned legislation that has been challenged in the Constitutional Court has been deemed invalid and has been struck off. So the refugees that have their asylum applications still pending, awaiting determination, are not going to suffer any unconstitutional acts, rather, just because they fail to renew a visa, because we understand the hurdles that come with that and the backlogs that Home Affairs is facing. Yeah. So it's essentially important, because when you deal with a refugee and the Refugees Act, there are certain circumstances that apply there, and once they're out of status and then it falls them into the Immigration Act, then you expose them to a lot of risks and leave them vulnerable to going back to a country that they fled.
I always like how you make the legal matters easy to follow and understand, and I'm sure our viewers appreciate that. Thank you so much, Canny, for just giving us a sense of this important judgment, because it is quite significant and a lot of people were still trying to get their heads around it. Hopefully, Canny's explanation has been able to assist you in terms of understanding this judgment better. That's Canny Maphanga, the SABC News legal reporter.